Okay, everybody, we should get started with topic number 2, returning to some housekeeping items. For all of you, those slides that are shown today, that are used today, will be posted on our website, so you can get them right off of our website. So on topic number 2, which is directed to future topics, is specifically geared towards potential topics we may discuss at upcoming roundtables. As Bernie and Michelle mentioned earlier, it's our plan with these roundtables and the partnership is to have a continual dialogue and have more meetings in the future so we can flush out as many issues as possible and keep the communication lines open. So for topic number 2, we have 5 speakers. Each speaker will have 5 minutes. And our first speaker is Mr. Edward Goodman, an analyst from Hattery Labs.
Good morning. Thank you for having me. I'm Ed Goodman. I'm both an analyst at Hattery Labs, which is a San Francisco-based seed stage investment fund and innovation lab, where I focus on data analysis and economics. I also manage policy and research for Engine Advocacy, a nonprofit group working to connect startups and policymakers. Engine has about 500 members around the country working to connect startups and policymakers, including Mapbox, Uber, Food Spotting, all of whom use, design, and develop software as some part of their business. We're encouraged today by the opportunity to provide input on the software partnership. I firmly believe that for the United States patent regime to thrive, technologists and the PTO have to work together to keep the pace of innovation moving forward. Entrepreneurs, investors, and software developers, as you may know, have grown increasingly wary of the patent system, both in terms of potential litigation and in mustering their limited resources to file for and license patents. In a startup's first year, the company may run only on the savings of the founders, a few credit cards, and the ideas and innovations that run the company. Angel and seed stage investment often don't provide much financial breathing room, making the fees and time associated with filing for a patent a luxury at best. Meanwhile, non-practicing entities are targeting smaller and younger firms. As Professor Chen has highlighted in her excellent work, at least 55% of companies targeted by NPEs have less than $10 million in revenue, and the more funding a startup raises, the more likely it is to be sued by an NPE. I have personally talked to co-founders who aim to keep the news of receiving funding under wraps or have avoided ramping up revenue growth so as not to attract the attention of potential litigants. These patterns stymie company growth and have a negative effect on our economy as a whole as we rely on new firms for job growth and increased competition in markets. Research has shown that while big firms pay more fees in terms of NPE suits, the share of revenue paid by small firms makes up a bigger share of their bottom line. These pressures have eroded tech entrepreneurs' trust in the patent system. Companies and organizations, including Twitter, are creating defensive patent systems to help innovators avoid the negative externalities associated with patent litigation. As 2 Washington University economists noted in the Journal of Economic Perspectives article recently, engineers are actively told by companies not to search, view, or speculate on patents. As one Microsoft engineer testified, ignorance is bliss and strongly recommended when it comes to patents. So how can the startup community help? We usually think about things in terms of how to solve problems and how to fix things and how to build things. So I have a few ideas today to present, and I think one focuses on a more near-term solution and one on a more far-term. In the near term, I think there's a real opportunity for the PTO to engage with the innovation community on prior art resources and other research for patent examiners. Google has already released a robust tool linking its search engine to the US and EU granted and published patent records. While this is a great step, it represents a pretty basic innovation in terms of what could be accomplished by leveraging community-based research that's really exploded over the last decade. To address this, the PTO may consider harnessing the active community of patent watchers, tech geeks, software developers, and others as a resource. Communities ranging from Quora to Wikipedia have demonstrated the Internet's capacity to harness collective intelligence, cut through the noise, and provide reasonable guidance on any number of issues. Groups like Code for America are demonstrating what teams of engineers with access to government data can accomplish to benefit citizens and businesses and communities around the country. And these are models that could be replicated for government agencies such as PTO. More than a decade ago, another resource-constrained government agency, NASA, successfully launched a ClickWorkers project to map the surface of Mars. After about 6 months and over 1.9 million entries, the survey work was almost indistinguishable from that of a professional geographer. It's not a perfect case study, but a pretty good example of how technology has been used to bring the insight of ordinary citizens into problem solving at a massively complex level. Patency and re-examination also take too long. This is true in the US and in other major patent offices in Europe and Asia. The tech community has the tools to help, whether that means collaboratively building tools with the government or independently developing platforms to assist the office. It should be a point of consideration as the BTO moves forward as they considers more in the software partnership. More generally speaking on the way we think about patents and patents' relationship to software engineers and other innovators. The PTO ought to draw lessons from what we've learned in the open source development and other community-based approaches to making software. While the patent system creates incentives for innovators to capture value through exclusivity and rent seeking, it's important to remember that many in the software community don't aim to immediately monetize creation. Lots of research has gone into the behavioral economics of the open source ecosystem and has shown that developers freely share their work as a means of boosting notoriety, enhancing their skills, or simply leveraging a transparent system for learning. To me, this is what the patent system doesn't really currently provide, a transparent, reliable resource through which the many can create technological progress while protecting the few who create truly unique ideas. The confusion created by overbroad patents flies in the face of platforms like GitHub that demonstrate the success of flexible, responsive, and accessible repositories in the software community. I spend almost all of my time surrounded by startups, developers, and entrepreneurs, and I can think of none that would use a patent to instruct the development of a product or a new user experience. For a successful long-term partnership between PTO and the software community, and to eliminate the problem of overbroad software patents, we need the Patent Office to speak in the same language as those driving innovation in the US. I hope this is the first in many conversations about how to move forward. These are just a few ideas, and I hope we'll have the opportunity to discuss them more in depth in the future. Thank you.
Thank you very much, Mr. Goodman. Our next speaker, Mr. John Ellis, who's an independent developer.
Thanks everyone for allowing me the opportunity to speak. Since I'm not a lawyer, I'll make this brief. I'm a programmer. I sometimes work on the analysis of patents, and I've noticed a persistently disturbing trend of basically rewording patents to make it sound novel and patentable when it really isn't. I work on patent analysis. Now, courtesy of our friends at Google, you can download the entire patent database without violating any federal laws. I checked. And more importantly, large storage arrays are cheap. $300 gets you 4 terabytes. That's enough to download and more importantly, analyze a significant part of the patent database quite cheaply. And whereas in other areas of law, like to download like case law, it's a restricted database. You virtually can't download a bulk, as I say, without violating a few federal laws. And I've used EC2 for doing large scale processing. It's really quite simple. And so there's the barriers to entry just aren't there. So my advice is, even though a supercomputer would be handy, it's not necessary to analyze patents because there's a huge amount of metadata there. So, ladies and gentlemen, just start coding and, So especially when I look at the bad patents, I noticed that from what I understand, most patent examiners start with a word-based search, and that's hit and miss. Because, as someone said earlier, patent applicants change the meaning of certain words and use their own language to make it confusing. And yeah, invalidating a patent is expensive. And they put the class data in the XML metadata, which is quite accessible, easy to index. You just got to have the data available. And one of the tricks I notice, this happens sometimes more than other times, is that when they change the classes that the patents are on, they make it harder for people to say, okay, these patents are related and very similar, but we don't want you to know that because our idea, which is really like the other guy's idea, is somehow novel. That'll be the day. Now, another thing I was noticing, because I downloaded, as I say, quite a large number of patents and went over them, and I noticed some terms keep popping up, like heuristic algorithm or over a network, and there's a few other terms, and they keep popping up, but they really don't make it novel, don't really mean anything. It just makes it sound like something that hasn't been done before. I mean, when did they first start sending computers to the moon? Was it 1969? Surely someone can patent a new way of sending things to the moon. Now, the solution is that we don't need to, even though the Patent Office has been around a long time, the data is very accessible. The XML files are there, the document type definitions are there for the patent data. They do quite a good job of defining it. There's not really a deficiency there. And on the EC2 platform, you can download common databases, common indexes without, and so if a friend from Stanford or a friend from anywhere wanted to do work on something similar to what I was working on, they could download an EXO index, minimal resources. And I think that the more people, the more eyes that are on this problem, the easier it is to solve. And it's not because the examiners are, they're highly intelligent people, but there's a limit to how much time they have, they can't be experts on every single little nuance of these patents. And so if we can all make a difference. And anyway, I figured I'd put my contact info, neurofog@gmail. There's a story behind that, but it's like brain fog, but slightly different. Anyway, thanks everyone, and I appreciate the distinguished speakers that I've been standing next to, and thanks very much, Mr. Hirschfeld.
Thank you, Mr. Ellis. So our next speaker is Mr. Tim Molino, Director of Government Relations, BSA.
Thank you for giving me the opportunity to speak on this very important topic. Again, I'm Tim Molino, and I'm the Director of Government Affairs for BSA, the Software Alliance. I'm also a reformed patent attorney. So BSA is an association of the leading software companies that invest billions of dollars a year to create software tools that spark the economy and improve modern life. We promote policies that foster innovation, growth, and a competitive marketplace for these kinds of technologies. I'm here today to highlight the importance of the software industry to innovation and our nation's economy. I mean, that's really why we're here. We wouldn't be having these discussions if it wasn't that important. Why patents in the software field are vital for maintaining our country's leadership in software, and then how the PTO should pivot from its current proposals specific to software and begin having in-depth conversations regarding more effective ways to improve software patents without discriminating against them. As has been discussed by others this morning, computer software is ubiquitous to our society. It's used not just for word processing, spreadsheets, or running smartphones, but it's also used for designing bridges, diagnosing diseases, and directing our energy infrastructure. Patents provide incentives for software companies to innovate, just as they do for other companies in other technological fields. Along with copyrights, BSA member companies hold a significant number of patents to protect the intellectual property they create through their substantial investments in research and product development. Because patent policy plays a central role in promoting innovation that has kept the United States at the forefront of software and hardware development, BSA members have a strong stake in ensuring that the patent system functions effectively and efficiently. Since the Diamond v. Deere case more than 30 years ago, the principle that software implemented inventions qualify as patentable subject matter has been settled law. The software industry has grown up relying on that well-settled principle and has become a major contributor to the U.S. economy, now adding close to $300 billion in value to our country's GDP. While BSA believes that the ability to patent software promotes innovation, we are also cognizant that the process can always be improved. Software is no different in this respect from any other type of invention. We understand that the PTO is never going to be a perfectly tuned machine. Patent examiners are human beings who will have to always make judgment calls and weigh evidence. The PTO's current proposals to limit how software claims are written and interpreted, however, appear to go too far. A patentee should be allowed to draft claims in a manner that best describes the metes and bounds of his or her invention, regardless of the technological field. So long as you comply with 35 U.S.C. Section 112, you should not be limited to how you claim your invention. But there are plenty of ways we can make the system better. We should implement those kinds of sensible improvements instead of taking extreme measures that would amount to throwing the baby out with the bathwater. At BSA, we believe there are several important issues that the Patent Office should consider for future software partnership discussions. First, the PTO should hold future discussions with industry and the patent bar to discuss the best ways to provide patent examiners, especially those in software units, with additional training, resources, and guidance with respect to examining applications under 112. We understand that this is not as simple as it may sound, which is why the topic should be explored further. But better trained and equipped examiners will clearly help improve the system. Second, the future discussions should also include developing a strategy for effectively encouraging examiners to more vigorously scrutinize claims under Section 112. It's a little different than the first topic. They can be trained, but they need to know how to use it, or they need to be encouraged to use it. The patent system would benefit greatly if examiners were more rigorous in their enablement and written description analysis. This would help ensure that only claims supported by the specification are allowed, and we need to explore ways to encourage examiners to do this. Finally, the software partnership should engage in a robust discussion on the best ways to aid the tech industry in developing common descriptions for software technologies. Common nomenclature will help examiners, courts, and competitors do a better job of determining the full scope of the claimed invention, and this is clearly worth further partnership discussions. On behalf of BSA, the Software Alliance, I thank the Patent Office for the opportunity, and we look forward to working with you in the future.
Our next speaker is Aaron Greenspan, Codex Fellow at Stanford Law School, who's going to be participating by WebEx.
I'm speaking today as an entrepreneur who's also a fellow at the law school in the Codex program. And so, as it so happens, last week I was given a notice of allowance for my first patent. And in the process of getting to that point, it's taken about 5 years and cost about $65,000. So I wanted to discuss some issues related to software and patents and software patents. The first is that even if I wanted to find a software patent today, it would be very difficult to do so. The official way that you answer the question, does IBM own any software patents, is by going to the USPTO website and then clicking on the patents link and then scrolling to the bottom, which you might or might not know to do on the search page, to get to the patent assignment database. And once you get to the patent assignment database, then you might be able to type in the name of a company, in this case just picking on IBM because I think they can handle it. Look for IBM, and then you get a very long list of numbers corresponding to patent numbers and application numbers and so on. And then you get the assignment information, but you still really would have no idea if this is actually a software patent based on the name alone. And you may or may not be able to rely on the classification numbers. They're not particularly reliable from everything I've heard. So if you wanted to do that the way that most lawyers would do it, you would pay about $300 in fees per month, and you would ask Westlaw, does IBM own any software patents? And in that case, you get to the Westlaw screen and you do the same thing. You type in IBM, you get a long list of numbers, which in this case looks a little bit different, but is still not particularly informative. And then you'd find that it found the letters IBM in a block of text, but it's still not particularly helpful. So what I've been working on at Stanford is a new website called PlainSight, and if you were asked the same question, in this case you'd go to the IBM profile, which also lists court cases, all of their attorneys, related companies, payments to lobbyists, and so on. And then you'd get a list of patent assignments, and a hopefully more easy to read view with the ability to filter by document type as well. And then you'd have a more clear version of how the assignments are actually working, and all the parties are hyperlinked, so you can follow those links, as well as the attorneys who are correspondents for those assignments, as well as the law firms they work for if they're available. And that seems simple enough, but it's actually a little bit more complex because, as straightforward as it may seem, IBM can actually be spelled a number of different ways. You've got different representations of abbreviations like corporation as corp or inc. You've got department numbers, you've got complete misspellings, you've got IBM with 2 I's, corporations without a P. And in summary, there's 1,185 ways to spell IBM. So if you go through the entire USPTO patent assignment database, there's likely over 100,000 typos that are material, so these are not insignificant. They actually affect search results. It makes it very hard to find information. In general, the USPTO systems, again, coming from the perspective of somebody who's just finished the process, I guess, of at least getting patent protection in the U.S., most of the systems the USPTO relies on today are completely obsolete. And the patent backlog that is, the source of an enormous cost to entrepreneurs and enormous cost to society is, I think, driven in large part by this obsolete IT. And there's really no better example of this than one of the pages associated with the PAIR database, where it says, how do I associate my applications with my customer number? And the answer is download the customer number update template, and after filling out the Excel spreadsheet, save it on a floppy disk or CD and mail it to the USPTO. So I don't think that's really the way in 2013 that government systems should be running. I don't think it would cost $65,000 to file a patent if things could be done over the web in an efficient format, which clearly this is not. So that, in summary, is a very quick view of why finding patent data is too hard. Second problem that others have touched on in their talks is patent trolls. Patent trolls love software patents, and that's, as has been mentioned, they're very broad. They offer enormous amounts of protection, even if the underlying material is not particularly solid. And so on PlainSight, you can actually view litigation. This is an example of a patent troll lawsuit against somebody who has a flight simulator program. The patent in question has to do with, I think, security mechanisms underlying the Android operating system, which are used in all kinds of programs. And as you can see, one of the useful features on the screen here is that you can tag this particular case as having to do with patent NPEs and software patents. So then, if you want to see other cases that are related to those, or other patents, or other companies, other attorneys, those can all be found in one place. This is a complex litigation view where you can see for patent NPEs a view by case, by entity, by judge, by court, and by law firm. You can see right now PlainSight's tracking 35 patent trolls, and of course among them there are some that are more significant than others. Intellectual Ventures, which probably everybody listening to this knows about, is arguably the largest patent troll maybe in the world, and you can actually see all of their shell companies on PlainSight. There's about 2,300 of them, and dig more into the software patents that they are asserting and the various mechanisms by which they, I don't know if it's that they're trying to hide ownership or they are just... I was actually toward the end of my presentation when it crashed, but just to finish up, I think I cut out when I was talking about Intellectual Ventures and their shell companies, so those companies are now available to see for whatever reason that they've been created that way, as well as all of their attorneys and all of their patent assignments, regardless of how they're spelled. And then to close, I just wanted to mention that there are a few minor improvements that the USPTO could make. For example, I have no desire to receive paper copies of all of the decisions made by examiners, so giving applicants the ability to opt out of paper and just receive everything by email or PDF would be, I think, a huge savings to the agency and just more convenient for everybody else. And also the fact that there can't be dual correspondence means that startups are basically forced to go through their lawyers as soon as they've hired them in order to prosecute their applications, when in fact there may be some questions that the inventors themselves or internal counsel for startups could answer, which would save money on the prosecution process. So I thank the USPTO for the opportunity and all of your patience with the technical glitches, and I hope that if you have any questions about Plainsight or anything else,